Good afternoon. Welcome to Vincent and Elkin's Energy Industry Series of CLE programs. I'm Jason Powers in Houston alongside Darren Tucker in Washington, D.C. And today we're going to be talking about antitrust law and enforcement. Specifically, what you need to keep in mind about what's happened in the past year in the antitrust space if you're helping to guide energy or petrochemical companies as they enter into major transactions or go about their business. A few housekeeping items before we begin. First, on your screen, you will see our speaker as well as our presentation slides. You can choose how much of each you'd like to see, and there's a slider on the bottom of your screen, and you can pick to make the slides bigger or smaller as you prefer over the course of the presentation. Second, we want our presentation today to be as helpful for you as possible, and so if you've got questions, we'd love to know about it. Over on the right side of your screen, you should see a moderator chat button. Looks like a silhouette of a person with a little message icon on top of it. Feel free to click on that icon and type in any questions you have, and those will be forwarded to us during the course of the presentation. We'll try to make sure that at the end of the afternoon, we save some time to answer your questions as we go along. And then finally, our discussion today is accredited for continuing legal education credit. You will see polling questions that pop up during the course of the presentation asking you to verify that you're watching. Make sure if one of those pops up that you click on it and verify that you're watching. In some jurisdictions, we can't submit your attendance for credit without that verification, so we appreciate your help with that. I want to get right to the substance today because 2021 was a very interesting year in antitrust. Changes in Washington always portend changes in the antitrust environment. And with a new presidential administration, we've had changes in who's at the helm of our federal antitrust policy. To fill us in on those changes and what they mean, we go to Washington to hear from my partner, Darren Tucker. Darren has been practicing in the antitrust space for more than 20 years. Both at the Federal Trade Commission and in private practice. He works with clients in all aspects of antitrust, whether they are facing governmental investigations at home or abroad, are engaging in major transactions that will be undergoing regulatory scrutiny, or just advising companies on competition law issues here in the U.S., in Europe, or in Asia. He's also active in the antitrust bar. He's currently the publications officer at the ABA section of antitrust law, and chaired the editorial board for the current edition of the ABA's treatise on antitrust law developments. Darren, why don't you tell us what's on the agenda today and tell us what you're seeing in Washington?
Great, thanks very much, Jason. Maybe go to the next slide. And just one final comment to add to Jason's introduction. V&E puts out a report every year talking about antitrust developments in the energy and chemical space. So if you're interested in learning more about what we cover today, you can get a copy of that from any of the program organizers or just Google Energy Antitrust Report and that should come right up. And of course, as Jason mentioned, we're happy to take any questions at the end of this program. So the last year has seen some extraordinary changes at the antitrust agencies, in particular the FTC. And I think you'd have to go back to the early 1980s to see a comparable degree of change in terms of the policies and practices of the agencies that we've seen over the last year, really over the last 8 to 9 months. So I'm going to talk about the new Biden administration antitrust enforcers at the two agencies, spend some time talking about the changes that we've seen over the last 8 or 9 months at the FTC and DOJ. And I think as you'll see as we go along, I'm going to spend more time talking about the FTC than the DOJ, simply because there have been more policy changes at the FTC for reasons that I will touch on as we move along in the program. And then I'll conclude with some comments on a recently announced program or policy initiative to revise the horizontal and vertical merger guidelines, one of the most significant policy statements of the two agencies. I'll then hand it back to Jason, who will cover developments in state and private antitrust litigation relevant to energy chemical companies. And similar to me, we'll then conclude by offering some comments on what may be sort of around the corner in terms of litigation developments for those industries. Next slide. So we have two new heads of the agencies at the FTC and Antitrust Division. Both were nominated by President Biden and confirmed by the Senate last year. So Lina Khan is the new chair of the FTC. It does not really fit the mold of a FTC chair by historical standards. She graduated from law school only in 2017. She's only 32 years of age, but she is, very well regarded and was pushed for very strongly by progressives. She really made a name for herself in law school. She published an article that called for an expansive approach to antitrust and was in particular critical of practices by Amazon. Since law school, she served on the Hill, worked on a big tech report, and also is an associate professor at Columbia Law School. And she's been in place at the head of the FTC since June of last year. Then over at the DOJ, Jonathan Cantor is the new head of the Antitrust Division of the Department of Justice. He's been in place for a lot less time. He was only confirmed in November, so he's had a lot less time to roll out new policy initiatives at the Antitrust Division. And his background is also quite a bit different than Khan's. So Cantor is a longtime antitrust lawyer. He started out as an FTC staff attorney, but has spent most of his practice as in the private sector. He's worked at large law firms, and he's represented large companies at those law firms. So it's a little bit different from the usual candidates that the progressive movement has supported. Where he got his support from the progressives was the fact that he was quite critical of some large tech companies and made a name for himself in that area. And I think largely for that reason, as well as his just general reputation as an antitrust lawyer, earned the nomination. A lot of progressive support. But I would just emphasize, again, that even when he was advocating against certain tech companies, he was actually doing that at the behest of other tech companies. So he really does come from the mold of a sort of a traditional antitrust lawyer's background. And again, has represented lots of companies in investigations by the FTC and DOJ. So we may well see a somewhat different agenda coming out of the Antitrust Division than the FTC, given the different backgrounds. Next slide. So I'm not going to spend a lot of time on this, but I do want to just make the point that the changes I'm going to talk about at the FTC and DOJ are not occurring in a vacuum. There is a real push throughout the government and even outside the government to really expand and have antitrust enforcement be more aggressive. And so we're seeing, for example, the Biden administration has really emphasized promoting competition across the economy. For example, the Biden administration issued an executive order in July of last year to promote competition. Some of these initiatives were antitrust focused, some were not. Some were just regulatory based to try to encourage competition through other means. There's also a lot of activity on the Hill. There's a number of different antitrust bills that have been introduced. These are largely aimed at the tech sector, but not exclusively. And some of those are making some progress. One of those bills, I believe, is actually headed for markup this week. Next slide. So let me focus first on the FTC. So one of the key things that we're seeing at the FTC over the last year in terms of a trend is more focus on the energy industry, and in particular on energy industry transactions. So if you go back and look over the last few years, it's actually quite remarkable. There was not a single speech or statement by an enforcer at the FTC discussing the energy industry prior to 2021. They just did not talk about the industry. Lots of speeches on the tech industry, pharma, healthcare, other issues, silent on energy. That all changed in 2021. And you've seen both the new chair and the new head of the Bureau of Competition indicating that energy mergers are now front and center of the attention of the agency. So probably the best example of this was an exchange of letters between the new chair, Lina Khan, and Brian Deese, who's on the National Economic Council. So Brian Deese sent a letter to Khan It was a very short letter, essentially expressing concern about gas prices for consumers, going up last summer, and raising questions about whether the FTC can do anything about the rising gas prices. And this is something that we've seen many, many times. Whenever there's a run-up in retail fuel prices, you often see folks on the Hill or the White House send letters to the FTC, either asking them to investigate this or just to express an opinion on why gas prices are going up. And the FTC, on a bipartisan basis going back decades, has essentially responded in the same way each time, which is that the FTC has always been very aggressive. They look at fuel transactions. They have lots of other mechanisms to look for any anti-competitive behavior and essentially tout the enforcement that they have made in that sector. And then sometimes also they have issued reports which reach the common sense conclusion that retail fuel prices are heavily influenced by petroleum prices, which are set on a global basis, which is highly competitive, and there's really nothing the FTC can do to affect those prices. So that was the standard response to these sort of letters. Hahn took a very different and very interesting approach instead. Instead of praising her agency's prior efforts in this sector, she criticized her own agency in saying that, in fact, the FTC had enabled significant consolidation in the retail fuel space and that had led to price coordination and collusive practices. She was critical of large companies buying up family-run businesses, which is not something that's ordinarily a concern of an antitrust enforcer. She raised concerns about large national chains restoring higher prices through collusive practices, and raised concerns about chains forcing their franchisees to sell gasoline prices at unfairly high prices. I'm not sure there was much of a factual basis for any of these concerns, but those were the concerns that were expressed. I think they're quite revealing. And although this was really focused on the retail fuel sector, I don't know that the concerns are really so limited. I think the concerns are broader than just retail fuel marketing. Another interesting development was the Berkshire Dominion pipeline deal. I'm not going to go into the details of this. I think the big picture takeaway here is this was a pipeline deal. It ran into some headwinds at the FTC. The parties ultimately decided to abandon the deal. And the FTC then issued a press release, part of which I've excerpted there on the right of the slide. And Holly Vedova, the new head of the Bureau of Competition, praised the parties for abandoning the deal, but was also uncharacteristically critical of the parties for proposing the deal in the first place, because the FTC had blocked a similar transaction 25 years earlier. The Berkshire Dominion deal is also significant. I'll come to this a little bit later in the presentation. This was one of the stated reasons for the FTC reversing its 1995 prior approval requirement. Again, I'll explain what that means a little bit later. Next slide. So what's actually happening in terms of the FTC's review of energy and chemical transactions? So it's a mix of good news and bad news. So the good news is the vast majority of energy and chemical mergers continue to receive clearance. Second requests are relatively rare. And if you look at the actual number of enforcement actions, in other words, the number of times the FTC goes into court to sue to block a deal or demanding a settlement, there's really not been any change. Again, we only have about 8-9 months of data at this point since the new chair has come into office. But we really have not seen any departure from historical enforcement levels. And again, if you look at the actual enforcement actions in these sectors in recent months, the FTC's approach to these transactions, at least based on the public statements, appears to be consistent with what they've done in the past. So we're not seeing a huge amount of change there. The bad news is it's a little bit different at the investigation stage. So we are seeing more investigation of energy transactions. Not only are they more often, they seem to be taking longer. And this has been an unfortunate trend across industries, but it seems to be hitting the energy sector in particular. And where we've seen the biggest change are really on the larger, higher profile deals, just getting more scrutiny than they have in the past. At least ones that don't present very obvious antitrust concerns. We're seeing some indications that the FTC is applying a lower standard to issue second requests. There's not a a clear standard for issuing second requests. So there's quite a bit of discretion the agency has on this. And so you do tend to see some shifts from chair to chair or administration to administration. But it does seem like the bar for a second request has been lowered by some fair amount with the current chair. And we're also seeing more involvement by FTC leadership in decisions that are usually reserved for career FTC staff. FTC staff really manage investigations on a day-to-day basis. The leadership obviously is involved throughout the process, but is most involved at sort of the latter stages. And we're seeing leadership getting involved in more routine decisions earlier in the process. Next slide. Another trend we're seeing that is a bit unfortunate is less transparency in an FTC investigations, really across the board. This is not specific to energy or chemicals. And let me explain what I mean by transparency. So the antitrust laws are not particularly clear as to what is condemned and what is not condemned. If you look at the Sherman Act, the Clayton Act, the FTC Act, they really don't provide very much guidance. I mean, in a nutshell, they essentially say anti-competitive conduct is illegal. I mean, there's really not much more than that in the statutes. And so, of course, we have lots of case law that explains what these statutes actually prohibit or don't prohibit. But over the years, the FTC and DOJ have put out a number of guidance documents and policy statements that explain how they interpret the antitrust laws. And this is very valuable. It's valuable really for any government agency to do this, but again, I think particularly for antitrust agencies because of the lack of clarity of the antitrust statutes. And this is very valuable because companies want to comply with the law, and they want to know not only what the courts have said, but what the government agencies' positions are that are enforcing these laws in terms of what they cover. So it's very important for companies that want to comply with the law to understand what agency's position on them is. Likewise, if you're a company that is under investigation, you need to be able to understand what evidence and arguments to put forward to the agency to justify your conduct. And again, the only way you can do that is by understanding exactly how the agency looks at the underlying conduct that's in question. So that's the importance of transparency. And as I said, the agency has historically provided a lot of transparency, but in the current administration seems to be pulling back from that. So one example of that is the Section 5 statement. So Section 5 is, again, one of these very amorphous antitrust statutes that simply says that it simply bans unfair methods of competition. That's it. That's all you get from the statute. And this statute's been around for over 100 years, and the FTC had never explained how it interpreted the statute that it uniquely enforces. But then in 2015, my former boss, Commissioner Josh Wright, with the support of the rest of the commission on a bipartisan basis, issued a policy statement explaining what this meant. What did the statute mean? How would the FTC enforce it? And the two key principles were the FTC would use the consumer welfare standard and the rule of reason for deciding whether to challenge an act Section 5 violation. So what does that mean? What is rule of reason? What is the consumer welfare standard? So the rule of reason is the standard way you look at antitrust conduct. It is the default method that you look at conduct, and it has been around for over 100 years, reaffirmed by the Supreme Court numerous times, including just in the last couple of years. So it is really, the standard way of looking at things. This is not radical. What's the consumer welfare standard? That simply says that when you're looking at conduct, what you really care about at the end of the day is how does it affect competition? You look at that at how it affects consumers. What's the harm or benefit to consumers? And again, this has been the dominant way that we've looked at antitrust conduct, at least since the late 70s, as reaffirmed by the Supreme Court many, many times. So the Section 5 statement from 2015 was not exactly a radical statement. It was basically a reaffirmation of core antitrust principles to Section 5. Yet, in July of last year, the Commission, on a party line vote, withdrew that statement, saying it essentially impeded their ability to enforce Section 5 efficiently. Now, does this mean that lots of companies are now going to get sued under Section 5? No. I mean, the statute was never used very aggressively, although things could change. But I do think it is highly symbolic that the majority of the commission at the time and the current chair feel that there is a problem, apparently, with the rule of reason and the consumer welfare standard, which again have been the dominant, really the only methods that we have used, at least for the majority of antitrust conduct. going back at least since the 70s on a bipartisan basis and as required by the Supreme Court. Next slide. Another unfortunate part of this trend toward less transparency is the FTC withdrew from the 2020 vertical merger guidelines. As the name suggests, these were guidelines that explain how the FTC looks at vertical mergers. Vertical mergers are transactions between companies at different levels of distribution. So it could be a refining company acquiring a pipeline company, something along those lines, or a chemical company buying an input supplier. So the FTC and DOJ put out joint guidelines in 2020, but then just a year later, the FTC again on a partisan basis withdrew from those guidelines. They are still in place at the DOJ, however. But as I'll talk a little bit about later, both the FTC and DOJ have recently initiated a process to put out new horizontal and. Next slide. So in addition to providing less transparency, we're also seeing a greater range of concerns that the FTC appears to be investigating as part of their merger and non-merger reviews, which frankly exacerbates the lack of transparency. So again, historically, there has been a bipartisan consensus that the purpose of the FTC is to protect competition. That's the consumer welfare standard. That's what the Supreme Court, said we should be doing. But again, the FTC seems to be moving away from this. Again, the Section 5 withdrawal is a good example of that. There was a blog post by Holly Vedova, who's the new head of the Bureau of Competition. She cited concerns about the FTC's prior unduly narrow approach that had created blind spots, and that there was a need for a broader range of relevant market realities. Chair Khan issued an internal memorandum around the same time that called for a, quote, holistic approach that considers harm to workers and independent businesses in addition to consumers. Again, getting away from this consumer welfare standard. And in fact, we've seen, or the agency has announced, a number of non-traditional factors may play a role in second request merger review, which I've highlighted there on the slide. Next slide. So there have also been a number of merger process changes, again, just at the FTC, not at the DOJ. And these have maybe the commonality between all of these is that they are making what is already a very lengthy and burdensome process even more so. So let me take each of these in turn. So actually, going all the way back to February of last year, the FTC has ended the practice of granting early termination. So this actually preceded Chair Khan. Her predecessor, the acting chair, actually put this into place, but it's continued under Chair Khan. So when you have a transaction that needs to be reported under the Hart-Scott-Rodino Act, you submit your filing, you pay a filing fee, and then you have to wait typically 30 days before you can close your transaction. And then the FTC and DOJ have time to review the deal during that time period. But parties can request early termination. And so if you have a deal that doesn't present any antitrust issues, the agencies can sign off on it prior to the end of that 30-day waiting period. That's what's called early termination. And historically, the majority of the time companies requested early termination, it was actually granted. That program was suspended last year on a allegedly temporary basis, but continues to this day. And so unfortunately, we've had many deals that have not been able to close, or there's been a delay in closing on deals that were either pro-competitive or competitively neutral because of the suspension of the early termination program. We've not gotten any indication of when that will be resumed. Second development is this withdrawal of the 1995 prior approval statement. I alluded to this earlier on the pipeline deal. So without going into the details here, what this really means is that going forward, there's going to be a new requirement in FTC settlement agreement that merging parties will need the FTC's permission to make additional acquisitions in the affected markets. So essentially what's happening here is the burden of proof is being flipped. So normally the FTC has the burden of proof of showing that a transaction is anti-competitive. They have to prove it in court. But under this New policy, if you settle with the FTC, future acquisitions in affected markets require the FTC's approval. So you basically have, you, the merging party, have the burden of proof of showing that your transaction is not anti-competitive. And it's the FTC that makes that decision. So it's basically giving the FTC quite a bit of an advantage in that process. Third development are warning letters. This caused quite a kerfuffle when this was announced last fall. And there's a blog post from the FTC on this if you want to learn more about it. But what happened is the FTC announced that they would start sending warning letters at or near the end of the 30-day waiting period in some transactions that were subject to the Hart-Scott-Rodino Act. And those warning letters would say that even though the waiting period was about to expire, that the FTC had actually not completed its review in that 30-day time frame, and that the parties would close at their peril. So this, again, caused a bit of concern that the FTC might be investigating or even challenging deals after they had received HSR clearance. So we saw a lot of parties, for example, making changes to antitrust covenants and acquisition agreements, and also just trying to figure out how best to manage this new risk. Well, it sort of turns out, with the benefit of hindsight, this hasn't really amounted to much. Parties are routinely closing over these warning letters, and we really have not seen any adverse consequences. The other thing I should add is that the warning letters didn't give the FTC any additional rights. They've always had the ability to investigate or challenge a transaction after HSR clearance. In fact, the FTC has a major lawsuit right now premised on exactly that. They're challenging some of Facebook's acquisitions from about a decade ago, for example. The final change we've seen are some changes to the second request process. I won't go into the details here, but again, it's just a number of changes that just make it more burdensome and time-consuming to go through any second request at the FTC. Next slide. So switching over to the DOJ, next slide. So not as much to talk about here, again, because Cantor has not been in office for as long, but I do want to comment on his confirmation hearing, which I think was quite instructive. I mentioned before that his background in some ways doesn't really fit the mold of someone coming out of the progressive movement. And in fact, he distanced himself from some of the more progressive views expressed by FTC Chair Khan at his nomination hearing. So for example, he was asked about the consumer welfare standard, and he did not object to it. And again, this is something that the FTC has been moving pretty strongly away from. Cantor did not agree with that, although he did disagree with, in some instances, how judges had actually applied the standard. He was also asked about the role of non-competition factors in merger review, in particular ESG consideration. And again, he distanced himself from, essentially the FTC's practices in this area. Now, he did signal that he does want to see more aggressive enforcement in certain industry sectors, and he singled out big tech, agriculture, and pharmaceuticals in particular. Next slide. And he gave a speech internally when he first came on board, and then he gave an external speech more recently, making some similar points that one of his goals is to actually bring more lawsuits and to settle fewer cases. The goal from this is that he wants to develop the case law more. He feels like there have been a lot of developments in technology markets in particular, and it would be helpful to have more case law in these areas to provide guidance to parties and to the agencies in terms of how the courts are thinking about these issues. Now, I will say that other enforcers have made similar comments in the past, going back over the last few decades. You frequently hear, newly installed heads of the FTC or DOJ say they want to bring more cases, they want to bring more lawsuits, but a lot of times reality then does, set in, because you can only bring so many cases, you only have so many litigators, you only have so many resources, and when parties offer a reasonable settlement, it becomes pretty hard to turn it down. So it'll be interesting to see how this actually plays out, over the next couple of years. So finally, I think I've alluded to this in several instances. We've now got a situation where, at least for now, there seems to be a pretty substantial divergence in some respects. respects between the way that the FTC and the DOJ are conducting them. Again, you have the FTC has withdrawn from the vertical merger guidelines. They're still in place at the DOJ, although I'll come back to that point in a moment. The FTC is moving away from the consumer welfare standard, looking at other factors in investigations, not really seeing indications, at least yet, that DOJ is moving in those directions as well. So right now, if you're a merging party, frankly, you'd rather be before the DOJ than the FTC. Not as though you have control over that. And in most cases, it's pretty well defined as to which agency you're going to be before. But it's sort of interesting over the years, folks like myself, always sort of think about which agency is better to be at. And it's always, sort of caused an interesting sort of academic debate. But I don't think there's any real debate today that if you're in the private sector, the DOJ is where you want to be. Now, again, Cantor has not been there very long, and things could change. But I think that's a fairly well accepted view at this point. Next slide. The last thing I want to cover before I hand it back to Jason is merger guidelines reform. So just recently, in the last few weeks, the two agencies announced a joint effort to review and revise both the horizontal and vertical merger guidelines, which is a very ambitious undertaking. The agencies have asked for public input on the process, and they've issued a series of questions on which they'd like to get input from the public, and that public comment is due on March 21. Next slide. So if you look at the questions the agencies have asked, may give us a little bit of an indication of where they may be going with this reform process. And I will say, prior to this reform process being announced, there really were not very many, if any, calls to reform the horizontal merger. Those were issued only in 2010, at the time under a Democratic administration. Vertical merger guidelines, from 2 years ago, those were a bit more controversial, but I don't think there was any real debate that they reflected, current enforcement practices. There were just some that on the left that believed that current enforcement practices should change, and the vertical merger guidelines, should essentially preview how those enforcement should change in their view. But so what is it the agencies are trying to accomplish with this reform effort? Well, again, based on their questions, it seems like there's an effort to rely more on structural presumptions, in other words, market shares, rely less on empirical-based evidence, and to introduce new factors, in particular in digital transactions or tech transactions, that might make it easier for the agencies to enforce or to find a violation. But again, we're still at the early stages of the process. The process is expected to take probably about a year. Now, on all of these different things I've been talking about at the FTC, the process reforms, pretty much all of them have been on a party line basis, with the Republicans objecting, oftentimes in fairly strident terms, to some of these changes. On this one, the Republicans did support the idea of seeking public comment to the revisions, but I think they previewed some concerns they have or may have with the end result of this process. They noted, for example, the importance of the new guidelines providing transparency and predictability to the business community and reflecting a consensus viewpoint. And I suspect what the Republicans are trying to emphasize here is that the direction that the Dems want to go here may be inconsistent with those objectives. So with that, let me turn it over to Jason. And just as a reminder, we're happy to take questions at the end of the program.
Thanks, Darren. Today, I want to talk about what's happening outside D.C., out in the state and federal courtrooms around the country, where state governments and private litigants go about the process of working through antitrust issues. When it comes to antitrust law, certainly, the courthouse is usually downstream of what's happening in Washington. If DOJ or FTC launch an investigation tomorrow, you can expect that whatever industry they're investigating is going to become the subject of lawsuits in the days and weeks and months to come. You'll have people and companies who are participating in whatever those investigated markets are, who start looking at whether they have potential claims to bring. You'll have state attorneys general who look into whether they might have some part to play in the process, whether they're bringing claims on behalf of their government units, or perhaps bringing claims on behalf of the public at large in their states. Those lawsuits will play out in courtrooms over periods of time that are measured in years, not months. So we always keep an eye on Washington to let us know what may be coming in the future. But when we look back on what was going on in the courtrooms in 2021, we try to figure out what can we learn from last year's cases that will help us defend next year's cases or help us understand what sorts of litigation lessons there are to be learned. And looking at 2021, I think there were three big lessons that we saw playing out in the cases being decided. And that was, one, when you're thinking about an antitrust case, you have to consider whether it's really an antitrust case. Second, plaintiffs and defendants need to keep the rules and procedures for bringing these cases in mind, because there are traps for the unwary and there are tools for the skilled on those things. And then third, and perhaps just most importantly from a compliance perspective, you have to remember antitrust cases are risky cases. They involve a lot of exposure, and there are potential risks that you need to keep in mind for your business. So starting off with that first lesson, is your antitrust case really an antitrust case? It's important to remember that antitrust law was really one of the first attempts in American legislative history to get into the regulation of commerce as such. Thurgood Marshall wrote once upon a time that antitrust law is the Magna Carta of free enterprise in the United States. And it really is something where the courts were given control by Congress to go figure out what's a fair way to compete and how do you go about regulating the competitive process. As a result, there's never a shortage of people in business who are facing competitive pressures, who are facing challenges, who are having frictions in the marketplace, who look at antitrust law tools and they say, is there something in there that we may be able to use to deal with the issues that we are facing in our competitive environment? And there's no shortage of people who will just bring whatever competitive issues they have, any business issues they have, and sort of slap the antitrust label on it and try to go to a courthouse. And sometimes that means courts are having to draw lines around what is really a claim that deals with the compromise of competition, as opposed to a claim that someone is simply complaining about some other kind of business wrongdoing that really belongs in some other area of law. Importantly, an area of law that doesn't involve treble damages the way antitrust law does. And we saw that playing out several times this year. One of the key examples of that was the Commonwealth of Pennsylvania versus Chesapeake Energy Corporation. This was decided in the Pennsylvania Supreme Court last year. It's a case that's part of a series of cases that have been kicking around for a while. You had a group of landowners in Pennsylvania suing Chesapeake and Anadarko on the theory that those two companies had entered into an area of mutual interest agreement, and they had divided up areas in the Marcellus that they would go try to lease up for drilling purposes, and then share each other's leases after those leases were obtained. When the cases first started, the primary concern by people like me was, do AMI agreements really belong in the same category as market division, which is kind of a classic antitrust cartel activity, and it's one that is rather easily prosecuted as a criminal matter. Over time, some of these private cases and state cases morphed into a different theory of the case. And in the Pennsylvania matter, you had the Pennsylvania Attorney General arguing that when Anadarko and Chesapeake went out to talk to mineral owners or landowners, they weren't disclosing the fact that they had partnered with one another and weren't, in fact, really competing for leases. So the Attorney General of Pennsylvania brings some cases under Pennsylvania's Unfair Trade Practices and Consumer Protection Law, which you would call a UDAP or a DTPA statute in other states. Now, certainly, sometimes when you have competitors who are coming together and they engage in practices where they mislead consumers about the terms on which they're dealing, that is the kind of thing that might involve antitrust issues and consumer deception issues. So the idea that there might be overlap here is not completely out of left field. But mineral leasing is a little bit different from selling gasoline or selling products in a grocery store, because when an E&P company leases minerals, The E&P company is not in the position of a buyer. Sorry, not in the position of a seller. It's in the position of a buyer. The seller in that transaction is the mineral owner. It's the landowner in some place in Pennsylvania. And so the Pennsylvania Supreme Court looks at this consumer protection statute that the AG is bringing the case under and says, this is a statute that protects consumers. It protects buyers of products. This is not something that affects this kind of transaction because the allegedly victimized person, the mineral owner, no, they're a seller. They're in the position of a seller. And since Pennsylvania was bringing this antitrust claim under the authority provided by this consumer protection statute, the Pennsylvania Supreme Court said, no, you're going under the wrong law. This doesn't belong in a consumer protection case, and the case had to be dismissed. A similar type of issue where you've had just a difference in understanding of what the antitrust law's impact would be in a particular case has been these market manipulation cases. And there's been a number of these over the last few years, but one of the ones that got decided this year as a good example was Midwest Renewable Energy versus Archer Daniels Midland. This is symbolic of all these cases where you've got some major trader that is big enough to influence a particular market. And that trader might start trading strategically in a way that ends up hurting other people in that same marketplace. In the ADM cases, Archer Daniels Midland is one of the biggest players, the biggest player, for the ethanol market at the Argo terminal in Illinois. And the claim that was being pursued in this case and in similar cases being brought in the same court was that ADM was flooding the market at Argo with ethanol. And the purpose of that was allegedly to manipulate benchmark trading prices and help ADM make more money on the financial hedges. Now, if you've had lots of traders in these cases who are saying that trading strategy was resulting in low prices and it was hurting them, it was causing them to have lower profits. But the federal court in Illinois has been dismissing several of these cases, saying that, look, the goal of antitrust law is to have lower prices. And if your complaint is that ADM is flooding the market and keeping prices too low, your complaint's not really an antitrust complaint. You would have to convince the court that ADM was literally trying to drive competitors out of the market and then raise prices, years down the road. And plaintiffs aren't making those claims because they're not going out of business. They're just complaining that they have lower profits than they would if ADM weren't putting so much supply out there. So the courts have been saying to plaintiffs like this, if someone's manipulating a market, go get the market regulators to look at that. If your complaint is that you're facing low price competition, don't come to the courts looking for relief under antitrust law because that's not an antitrust claim. It's an interesting kind of case that I hadn't seen much of before, Penthol versus Vertex Energy Operating. This was a case decided last year on a motion to dismiss. It's still going on, but the antitrust piece of it is over. Penthol sells Group 3 base oils, and they had signed up Vertex Energy as a North American distributor. Penthol had agreed to all kinds of restrictions that said Penthol wouldn't go around their exclusive distributor and sell directly to customers on their own. A typical kind of protection that you might have in a producer-distributor deal. And in that case, it's typically fine under antitrust law to have those sorts of restrictions because, yes, it keeps Penthol out of the market itself, but that's for the purpose of encouraging its distributor to put more of its eggs in that basket and to actually promote Penthol's sales into the market. So on balance, that's good for competition in the base oil market. Then a few years later, after this deal gets signed back in 2016, something unexpected happens. Vertex decides to get into the business itself and start selling base oils on its own for its own banner. Penthol alleges that Vertex was giving preferential treatment to its own house brand, if you will, rather than selling the Penthol oil that it had agreed to distribute. Penthol sues and says that the arrangement that they had entered was an anti-competitive agreement because it locked Penthol out of the market. And the court dismisses the antitrust claim. And it says the Sherman Act does prohibit you entering into a contract to restrain trade and to exclude someone from the market. But 5 years ago, when this contract was entered, no one was trying to lock Penthol out of the market. This was designed to promote Penthol sales, and you can't have a conspiracy to restrain trade if the contract wasn't, in fact, trying to restrain trade. Now, that doesn't necessarily mean that Penthol is without any remedy at all. There could be other ways in which Vertex has breached an obligation to Penthol, perhaps breaching a contractual obligation to promote their products. There are other claims that are being brought in the case that are still set for trial next year. But an antitrust claim, it's not, because that contract was not entered at a time where it was trying to prevent one party from getting to the market. One interesting case, this is something that hasn't come up much before. It's a state court case out of Texas, the Western Marketing case versus AEG Petroleum. It shows an interesting overlap between antitrust and what's called anti-SLAPP statutes. And if you're not familiar, SLAPP refers to strategic litigation against public participation, or the idea of using lawsuits to intimidate someone and bring the pain to someone who's making public comments that you don't like. A number of states have passed statutes saying that if someone has sued you over the exercise of your free speech rights, then you might have an early opportunity to seek dismissal of that case rather than be subjected to the cost of litigation. The Western Marketing case involved a plaintiff who was a seller of bulk lubricants who said that defendants were trying to run him out of the market by bad-mouthing him with potential customers, and the court agreed with him up to a point that kind of lawsuit could be something that is infringing on your ability to speak freely about your competitors. The Texas statute's got some very specific terms in it about what kinds of speech are covered, commercial versus non-commercial, whether it's generally to the public or to customers that you're dealing with. And so there are some technicalities involved there. But the court acknowledges this idea that if you are suing someone over the exercise of their speech rights, and that's what has the competitive effect, you might have an opportunity to challenge that under these anti-SLAPP statutes if you're in the right court. That statute doesn't have application in the federal courts necessarily, but in the state courts, it will. And there'll be similar state provisions in many other jurisdictions. Brooklyn, if we go to the next slide, please. One thing that's really important in any antitrust case is to remember what the procedural requirements are, and they get particularly complicated when you're dealing with large-scale litigation, as antitrust cases often are. Courts will take you to task if you mess up in terms of meeting deadlines, disclosing information that you need to disclose, and so forth. And we saw significant cases having significant problems on those scores. In the Black versus Oxy Petroleum case, this was a case, it is a case involving mineral owners who were alleging monopolization over some leasing and drilling opportunities in Wyoming around old railroad lands. The case was brought as a class action. A class action briefing schedule was set up. The plaintiffs moved for class treatment. There's expert reports. There's briefing. A lot goes into getting a class certification process underway. And after the defendants had responded to the plaintiff's motion for class treatment, the plaintiffs, in essence, agreed with the defendants on some parts of the criticisms, saying that the plaintiffs had sought a class that was too broad, covered too much. There were people in the class who weren't really injured. And so the plaintiffs, on their reply brief, tried to narrow things back down and cabin that class definition and make it perhaps more amenable to class treatment. And the court says, no. We've had expert reports, we've had evidence, we've had briefing. If the class you moved for is not the class that you want any longer, then I'm denying your motion, and you're going to have to go file a new motion and give the defendants a fair chance to respond to the class that's actually going to be tried in this case. Similar kind of problem in the Bartlett versus BP case. This is one of a group of cases about refiners allegedly coordinating refinery shutdowns and fuel price increases. The plaintiffs served expert reports in the cases, and lo and behold, they had all kinds of information about diesel fuel prices being increased as a result of an alleged conspiracy. And the pleadings in the case hadn't talked about diesel. The discovery in the case hadn't talked about diesel. And so why is the plaintiff's expert showing up and talking about this entirely different product all of a sudden as you get into that class certification stage? The court says this is far too late to change the subject of the litigation, and ends up striking a damages report and getting all those diesel fuel allegations out of the plaintiff's expert report, which took about a third of a $15 billion damages model off the table. So a pretty significant impact, and it sort of drives home the importance of making sure you've got your case lined up correctly from the beginning And on the defense side, you make sure that case isn't creeping in topic as the years go by. The request for injunctive relief has to be based on ongoing illegal activity. It's another California refinery case. This is a case where the party essentially is citing the wrong statute when they're seeking a certain kind of relief. They get dismissed because they're applying the wrong statute. The caustic soda case one I think is particularly interesting because it's a case where you've got a plaintiff who's trying to represent claimants in 23 different states. And the reason they want to do that is because they want to use all kinds of different state laws. Federal law will have some limitations on who can bring a claim, and state law might give you additional rights. And so it's frequently the case that in large antitrust cases, there's going to be a desire to have both state and federal claims going together. But the problem is that each of those states have their own procedures. There might be requirements to notify enforcement authorities. There's definitely going to be requirements to make sure you've got a plaintiff in those states who can represent the people who have rights under those state statutes. And if you don't have all those boxes checked, then when you get to trial, you may not be able to bring those state law claims. And in the caustic soda case, I said they're trying to bring claims on behalf of people in 23 different states. The court ends up dismissing state law claims under 17 different states' laws, obviously having a big impact on how many plaintiffs will be able to recover in the case. Obviously, antitrust cases involve significant risk. We'll go to the next slide. This was a pandemic year that didn't produce any billion-dollar judgments involving really major markets, but we still saw examples of disputes that imposed significant costs on defendants. A big one for the year was the $85 million judgment between Ingevity and BASF. This was a case in which BASF was alleging that it was being locked out of a market for fuel vapor capture canisters. It's a piece of the fuel system in a car. BASF convinced the Delaware jury that Ingevity, which was the major provider in the sector, had patent license terms that were locking BASF out of competition, even though its product, according to BASF, was superior and cheaper. And the jury agreed, and they awarded $28 million in actual damages, which was automatically trebled under antitrust law to $85 million. A number of different cases up in Missouri, propane tank settlements. We now have $19 million in those cases involving alleged coordination on how much propane goes into a tank. Predatory pricing claims involving a gas station that was allegedly put out of business because one of its competitors was selling below cost, taking advantage of state statutes that prevent someone from selling their motor fuel below cost. And I think one of the big ones for next year is going to be crop inputs. This is a case that involves herbicides and other chemicals that are used in the agricultural process. Like every other industry in the world, this is an industry where the online sales revolution has been creeping into a lot of incumbent business relationships. And here you had plaintiffs who allege that they are online sellers who were buying crop chemicals and putting them into online platforms that consumers found convenient. And then you've got the incumbent distributors and retailers who allegedly coordinated with the manufacturers to lock those new competitive online sellers out of the marketplace. The plaintiffs claim that caused prices to go up and prevented some new discount providers from taking hold. And a lot of the big players in the chemical space are named as defendants in those cases. Those cases began filing in February of last year. In the middle of the year, they were consolidated in a multi-district litigation in Missouri. And I'm sure that over the next few months, we'll find out what the courts think about the way those cases have been pleaded and whether or not they should proceed to the discovery and ultimately trial stages. So that's what's happened in litigation over the last year. We should talk about some of the questions we've gotten. One of those, and Darren, I'll be curious to know what you think about this. The Justice Department has been focused on no-poach agreements. These are agreements between companies that they won't try to hire employees away from the other one. And in the energy space, you see a lot of these deals. As one of our questioners points out, vendors are keeping them in their agreements. Non-disclosure agreements will often have no-poach clauses in it. But when are they okay, and when are they something that should be worried about? Darren, thoughts on that one?
Yeah, thanks very much. It's a great question. So just to give a little background, in 2016, the Department of Justice issued guidelines saying that going forward, no poach agreements would be prosecuted as a criminal violation. And then the DOJ actually brought its first no poach criminal case just last year. It involved some outpatient medical facilities where one of them reached out to two of their rivals and essentially agreed not to poach each other's senior employees. And so the DOJ charged them criminally for that conduct. Now, that doesn't mean that every no poach agreement is a criminal violation or a violation at all. What the DOJ is really going after here are what we call naked agreements, naked no poach agreements. So that's just literally companies agreeing among themselves not to hire each other employees without any potential efficiencies or justification for that conduct. So there are situations where you can have no poach requirements. So for example, if you're looking at a potential joint venture or you're looking at a potential acquisition, you probably need to know about the employees, particularly the more senior employees of the other company or companies that you're going to engage in this collaboration or acquisition. But in some cases, you might not actually go forward with the transaction, but you've wound up actually collecting potentially a lot of information about their employees, including maybe even their compensation or just who their better employees are that you might want to try to pluck off. And if companies didn't have a way to protect themselves from that sort of thing, it would discourage them from engaging in these negotiations in the first place. So the agencies do recognize a need in circumstances like that to have no poach agreements, but they have to be narrowly construed. The agreements have to be limited to employees where another party is actually getting information about those employees as part of a legitimate exercise, such as considering a joint venture or an acquisition, and they have to be reasonable in time. You can't have a no poach or no hire agreement that lasts 10 years, for example. That's just going to be too long from the antitrust agency.
Yeah, and I do think this is an important area to keep in mind that this is one in which the enforcement authorities are looking to make some law, and they're going to be looking for cases that they can bring. And so, as a result, if you are dealing with something that it looks a little bit strange, it's not tied to a particular deal, it's not limited in time, you probably want to run it by an HR professional or your antitrust counsel to make sure this doesn't have a feature that would be attractive to the agencies as they're looking for opportunities to bring cases. We also got a question about collaboration between competitors in the chemical space, for example. It might be the case that if you are trying to distribute a chemical, you've got a competitor who's got the capacity to do that distribution, and you'd like to take advantage of that. Does that create antitrust problems? Darren, what do you see in terms of that? I mean, especially given how the chemical space is so concentrated.
Yeah, you do tend to see a lot of cooperation among competitors in really the energy and chemical industries quite a bit. In fact, sometimes it's almost impossible to get your product to market without some kind of collaboration with other companies in the market who are oftentimes your competitors, at least at some level of the value chain. There's not necessarily any hardline rules here, but if you're talking purely about distribution, that's going to be a lot less risky than actual marketing or sales to end users. The agencies get very concerned when there's, a company is giving up pricing or marketing authority to one of its rivals. But if all you're talking about is just distributing, if you're using a competitor to get your product into a customer's hands or to a distribution point, that's going to be a lot less, risky than actually, having your competitor actually market the product for you to end users.
And I do think this is an area where in-house antitrust counsel or in-house compliance counsel want to make sure that they have adequately prepared their personnel who will be interfacing with a competitor, even if they're doing it in this kind of vertical arrangement where they're not in a position to horizontally allocate markets or set prices or things like that. It's important to make sure those people know that there are limits on what they should be discussing with that competitor, because those communications, they can be places where there are traps for the unwary. They could be places where it could turn into something that it's not supposed to be. And so making sure that they're adequately prepared and trained and know how to adequately document their dealings with the competitor is an excellent idea. Well, we've reached the 1 o'clock hour in the Central Time Zone and 2 o'clock in the East, so that's the year in the antitrust space in the energy and chemicals business. Darren and I would love to talk to you more about any of these issues. You can find us on the web. Feel free to call us on the phone, and we certainly hope this has been helpful to you today. So we're glad you came to visit, and we look forward to talking to you again next year as part of the energy series of CLEs. Thank you very much.